And the final case is D&E Real Estate versus Jose Rivera.
May it please the court, Justice Kaplan, Captain Young, Tyrone, on behalf of the appellant, and if the court would indulge, I'd like to reserve 3 minutes for rebuttal. There's 2 main issues. One was a threshold issue, and that is whether the contract terminated by its own terms on either March 31st or April 7th. And that issue is reviewed de novo. Now, if it did, the next issue becomes whether the court was correct in ruling as a matter of law based upon its own findings of fact that reasonable diligent efforts were not undertaken to cure title between contract and the date it was over. I would argue to the court that you can reach that issue on a de novo review based upon the court's own findings of fact. On the other hand, if the court wants to go even deeper into what the actual record is, I think that the court's findings of facts could in fact be disturbed, but I don't think you need to get there.
Say that again
for
me, I'm sorry, but
yeah,
that we can look de novo and make findings of fact based on the record and the de novo application.
Let me restate, and I apologize to the court. So the issue of whether reasonable diligent efforts were undertaken, the case law says, quote, that it's nearly always a mixed question of law and fact.
Right.
And I'm arguing to the court that based upon the court's own findings as a matter of law, that the trial court misapplied the standards set forth by this actual court. In the event that the court wants to go into the actual factual record, I would argue that there's an even greater basis, frankly, to disturb the court's findings, because there was no competent, substantial evidence upon which the court relied. If, in fact, this court reaches the conclusion, which I think is the right conclusion, that at some point my client's obligations terminated. I don't think you need to get there.
Well, and the threshold question is whether or not this expired by itself.
By itself, which is a question of law. It's contractual interpretation. So on that threshold issue, I want to bring up a couple of points. This particular contract, which is the same contract that this court looked at in Diaz that said that, this is the Florida Bar contract. It's a wealth of years and years and years of litigation trying to avoid this stuff. There are some very important contractual clauses in this contract that should control that I think that the trial court overlooked. Number 1, there is a set date for closing. Number 2, time is of the essence on that issue, on closing. Number 2, a waiver of anything else doesn't waive another provision of the contract. So, for example, the court found that my client waived the right to complain about timely obtaining financing, and I would argue to this court that that doesn't mean that it waived the time is of the essence clause, which had to do with closing. And that's plain, unambiguous contractual language. There is also, very important, I think, that this contract cannot be modified unless it's in writing and signed by both parties.
But let's talk about the set date for the closing. The set date for the closing, because it's to close within 60 days, would have been March
31.
the 31st. But on March the 6th, which is before the closing date, or the deadline for the closing date, you have D&E's attorney, Mr. DeJury, who contacts Mr. Littman, that's Mr. Vito's attorney, to notify him of this title defect. At that point, obviously, you're not going to go forward with the closing once the seller is saying, hey, listen, we can't close because this case is in bankruptcy and we can't do anything with the property.
And I think, listen, and the court said if you look at a strict reading, then it didn't terminate. And I'm saying, well, if you really want to look at a strict reading, that the appellee never triggered that 30-day cure period. However,
No, the appellee didn't, because at this point, the seller has essentially said, we have the defect, we can't go forward, we're trying to resolve this defect. So nobody, if you were to look at anybody triggering the cure, period, it would have been the seller, not the buyer.
I agree with the trial court and with this court, and the reason I'm agreeing is because I said, okay, I'm looking at this like the trial court. I said, what's the purpose of this contract? It is to transfer a piece of property. And to stand on ceremony on March 6th, when everybody had knowledge of this defect.
But it's not standing on ceremony. You have the seller still wanting to allegedly sell this piece of property and say, listen, we have a problem, we're going to try to resolve it. So now you have the buyer who's still interested in buying the property. It's depending on the seller to try to resolve the defect.
Which is why I believe that the proper, and I'm conceding for purposes of appeal, I think that it is proper not to disturb the court's finding that on March 6th, this cure period, this 30-day cure period would have been triggered, which is why...
But I think it's important to know how it got triggered. It got triggered by the
That's
seller.
right. And if you want to look at the records, again, I don't think you have to, but if you look at the records, there's testimony from seller's counsel, which he testified, said, I couldn't conceal this from the other side. I had an absolute duty as a member of the
He did the right thing.
He did the right thing.
Foreclosed.
So what happens? At that point in time, and I'm conceding,
Or in the bankruptcy.
right, and I am conceding that at that point in time, this 30-day cure period was triggered, because that's the only time it could have been triggered. And if you look at the contractual scheme with what
You're
happened...
saying at that point, after that 5-day period passed, then it had to ask for a 120-day extension.
No, I'm saying on April 7th. And in other words, what the court found, and I'm not seeking to disturb it, is that on March 6th, because they had knowledge, the court deemed the cure period to begin on that day. And that's what pushed the outside closing date from March 31st to April 7th. Now, on April 7th, in the event that title is not marketable by that time, the buyer, happily here, had some options. One of those options, the option number 1 was to walk away. Option number 2 was to close with the title defect. Option number 3, he had an absolute right within 5 days of April 7th to demand that closing date be extended for up to 120 days, during which point my client's obligations would have continued. He did not do that.
The emails in the record, like Appendix 98, where they're back and forth, should we extend the closing, or do you want to see, David, this is from Mr. Deary, David, in regards to 2601 and 2603, do you want to extend the closing date, or do you want to see if the buyer will walk away? And then the next email response after that same day, I think we should extend.
So here's, and I know why the trial court, that mattered in the trial court. There was further testimony that was internal discussion, that they ultimately opted not to do that. Whether the court trusted that or not as being true is not an issue before this court. Why? There is zero testimony by any party at the trial court level that the buyer knew that that was something that these sellers had considered. So the question becomes, by what operation of law, because you can't by contract, because there's no evidence to support a contractual extension beyond April 7th, by what operation of law can the buyer rely on to say, well, it was extended further? The court found...
Well, didn't the court find, based upon the conduct of the parties and considered that Mr. Littman also contacted Mr. Bandito, who's the bankruptcy attorney for Cooper and Ramos, and is asking about what's happening with the bankruptcy case, and Bandito is responding, although it looks kind of improperly because it's representing Imperial, that Imperial should not even have been in this, but let's take that for an aside. They're in communication, and he's telling the buyer, yes, they're still going forward with this. If you send us the contract, we need the contract. He sends him the contract. Doesn't this at least lull the buyer into believing that the seller is still trying to cure the defect and close on these two?
The answer to the court's direct question is yes, but it doesn't matter. Why? The critical point in time is April 7th. What did my clients do to lull the buyer into not extending the contract on April 7th? They had every opportunity to abide by the contract, and he did not. There is nothing in the record, that would support, in accordance with the law on estoppel, that on or before April 7th, my clients did anything at all to warrant application of estoppel to prevent my clients from claiming that the contract had terminated. On April 1st, there was an email sent by buyer's counsel not demanding, as was his right, to extend for 120 days, simply inquiring, hey, do you guys want to extend the contract? And I understand why he did that, because if in fact you want to get a deal done, you say, hey, listen, let's just do a written modification as required by the contract, and we'll push it off until some time. He didn't do that. Between April 1st and April 7th, the buyer, happily here, received 0 communications back in response to that inquiry. So what should the buyer have done? The buyer should have exercised his inalienable right under the contract to extend for 120 days, and he didn't. So on April 7th...
But hasn't he essentially done that? He's not insisting on having his deposit returned. He's not asking that the contract be canceled. He is operating under the supposition that this contract is still in force and that the buyer is attempting to cure the defect. So isn't this provision that you're relying on, and doesn't the case law say that the provision you're relying on is a provision that was to protect one provision was to protect the buyer, one provision is to protect the seller? It's usually the reverse. It's usually the buyer who discovers the defect and is putting the seller on notice, cure this defect, or walking away and I want my deposit back. This is the flip. You have the seller who is now telling the buyer about the defect, and therefore doesn't case law like Vermont and Kubasek and cases that discuss those provisions specifically say that it can't be the seller who has a defect who the trial court finds didn't make a diligent effort to cure. They can't then stand up and say you can't sue me for specific performance.
The answer is no. And there's 2 reasons why the answer is no. The first reason is purely contractual. The plain language of this contract, which, by the way, if you go back on the Diaz holding, this contract, this provision I'm about to tell the court, clearly came out of Kubasek. I mean, there's no doubt about it. The contract flat out says in unambiguous language that after this 30-day cure period, now I'm talking October 7th, if the seller is unable to produce marketable title through reasonable diligent efforts, then the buyer is deemed to accept title as is.
But the trial court found that the seller did not exercise reasonable diligence in trying to clear the title.
That's right, the trial court did, but how did he get to that point? If you look at the findings of fact upon which the court made that legal conclusion, there are only 3 things that occurred before April 7th in his finding.
What paragraphs?
Your Honor, I apologize. I'll tell you on rebuttal. I just don't have it in front of me.
Okay.
And I'm sorry. But
No, I get it. I'm following.
If I can, I believe it's on page. I'll have to come back to the court, and I'm sorry. But the court looked at the totality of the circumstances, and I will concede to the court that after April 7th, that there's a lot of facts that this court would not disturb. However, prior to April 7th, prior to the expiration of this contract and the expiration of my client's obligations, because the buyer did not exercise his right to extend and is deemed under the contract, I'll get to Kubasek efforts in a second, but is deemed under the contract to take title as is, the only things upon which the court could have relied to make a finding within that time period that there was no reasonable diligent effort is that the court did not, that my clients did not seek a declaratory judgment on behalf of the actual buyer. 2, they didn't file the motion to dismiss on an expedited basis, and that the hearings were continued numerous times. The problem with that is that even though that the court said
the bankruptcy court actually put the client's lawyers on notice that they could carve out this exception and go forward, that the bankruptcy court would accept that. And then there was no request for the bankruptcy court to do that, which could have cleared the title on this property, and they could have closed.
Here's the problem with that, and here's why I think the court was wrong in that. This court in 1983, in Glackman versus Hill, said that if you are trying to prove that reasonable diligent efforts were not undertaken because there were other alternatives, that those alternatives have to be reasonable and certain.
Well, aren't they reasonable and certain? If the bankruptcy judge says, if you submit this to me, I will grant it?
When the judge says that 2.5 months after the contract expired, it is a stretch to know, number one, would the judge have granted that at that time? We don't know what was going on in the bankruptcy
But there
court.
was no attempt to even take the judge up on the offer.
Because it didn't matter. Here's why it doesn't matter. My clients have their own inherent rights. They can do with this property as they please, except that when they entered into this contract, during the term of that contract, they have obligations. They have obligations that supersede doing what they want to do. The problem is that on April 7th, because the appellee did not exercise his rights to extend, my clients can alienate their property however they see fit. And that's the problem. There's zero evidence before the trial court of that these alternative means setting it on it. We don't even know if the bankruptcy court would have set it on an expedited basis.
The problem is nobody even attempted to, and
that's
the
the verdict.
record seems to suggest that there was reasons for that.
No, there's reasons after the fact, and that's another problem. The problem with this entire findings of fact.
I mean, this property was in foreclosure. They were trying to raise money in order to protect against the foreclosure. The foreclosure sale gets rescheduled because now the deposit of $170,000 or whatever it was now would satisfy what the bank was looking for in
Actually,
foreclosure.
the sale, not the
The
deposit.
sale. I
It's
mean,
the
so
sale.
they, right, enough, but it's the sale of the foreclosure. So that gets kicked down the road because of the deposit on these two units. Then, it goes into bankruptcy under very suspicious terms because the entity that has filed the bankruptcy proceeding is not the entity that has the interest in this property anymore.
Except the court found. No, it's findings of fact.
Yeah, but I just want to take it one step further.
Sure.
So you have all of that going on, and so the court is looking at, what was the real purpose? What's really going on here? Are they using the money of this deposit in order to stall this down so that they then can wait until this property appreciates, sell it to somebody for a much higher number while keeping, Mr. Vito or Dr. Vito dangling, thinking that he's going to close on these properties and then we're going to sell it to somebody else for a lot
Well,
more.
interestingly enough, in the complaint, there was a claim for fraud, which the court never entered a judgment for fraud. And I don't know why I didn't do that. I can only presume because
But when
they
the
didn't
trial court
need it.
makes a finding that you haven't made diligent efforts, doesn't some of that go into that consideration?
It doesn't. Under case law, it doesn't. Under Blackman, it doesn't. And but under Goldview, it doesn't. The fact of the matter is that the judge, because the judge overlooked the plain contractual language that it terminates at its own terms, when the judge was determining in toto conduct to determine whether there were reasonable diligent efforts or not, the overwhelming majority of the acts that were taken are after my clients didn't believe that they had an obligation. So to hold my
They
clients,
didn't wonder why they were being contacted?
the testimony, if I recall correctly, the testimony from counsel was, and actually I will point to on our appendix, beginning at it's on appendix, appellant's appendix at 809. If you go to a couple of pages in on a line of questioning, the seller's counsel, when asked, well, why didn't you respond? His response was, I did not have to, quote, I did not have to take the obligation for him to communicate what he should have known for himself and his clients, that there was a period of time that was of the essence of this contract, and the expiration of that time, the game is over. I don't have to call and tell people that we're at the fourth quarter, 0 seconds left on the clock. By the way, the game's over, because that's what the document says. And that also goes to whether or not the court was correct as a matter of law in applying estoppel. The law on estoppel is that if you're going to seek estoppel by silence, which is what happened here, there has to be some unequal position of the parties. What's the only thing that they can argue? The only thing that they can argue as to why the appellee did not exercise his rights to extend this contract for 120 days is that the silence of the appellant's transactional attorney in the face of an inquiry asking whether they want to extend whether the sellers want to extend the contract, lulled them into not exercising their rights. The problem is that both buyer and seller represented by counsel, both buyer and seller had the same contract, and both buyer and seller absolutely knew what the rights and obligations of both parties were, and the simple fact is, unrefuted, that the buyer did not exercise his rights, period. So under any matter of law, you can't get there. I'll reserve my coup, check versus White, because I'm sure we'll have more questions
Just use
after.
it, but I'll give you 2 minutes.
Thank you.
Thanks.
Good morning, Your Honors, and may it please the Court. I'm David Gay, and I represent Dr. Jose Vito, who is the appellee and the judgment holder in the having prevailed in the underlying trial litigation. Respectfully, this Court should affirm the trial court's ruling because the trial court's findings that D&E failed to use reasonable diligent efforts in good faith, whether that was during the time that they admit that they were required to use those good faith, reasonable diligent efforts, or after that, with the trial court having found that their argument with respect to the termination of the contract was faulty, is based on 12 pages of findings of fact in the judgment and 9 pages of analysis of those additional facts. Those factual findings indicate that there are a number of reasons the trial court found that D&E didn't use reasonable diligent efforts in good faith to clear title. Any one of those reasons, all of which independently support the trial court's findings, is sufficient to uphold the judgment. Now, as an initial matter, counsel this morning has said that the findings of the fact can be disturbed by this court. Then he, if I heard him correctly, later said that the court need not disturb the findings of the trial court. Regardless, there's no ability, respectfully, for the court to disturb the trial court's findings. One, because they're findings of fact, and two, because the appellant clearly states in their initial brief in at least 2 places that they expressly are not challenging a single factual finding by the trial court. They expressly state, it's on page 13, appellant here seeks only review of the trial court's legal conclusions based on his findings of fact.
Must the buyer extend the cure period if the seller from the beginning hasn't used diligent efforts to cure?
No, Your Honor, because the expiration...
The buyer does not have to do anything. The buyer can just sue for specific performance.
Correct, Your Honor, and that's because the contractual language, the specific language of the contract on which they really want to apply a strict reading with respect to certain parts of it, but not all of it, the language of the contract, in paragraph 18, says that it's upon the expiration of those reasonable diligent efforts undertaken in good faith that the contract can then terminate, which also has a contingency.
Without any penalty.
Which also has
return the deposit and you're done.
The contingent precedent being that the money is returned from escrow to the buyer, and therefore the parties will be relieved of further obligations.
But there's one breach, and once there's a breach prior to the termination date, then all bets are off and specific performance is available.
Correct, Your Honor, and their argument, literally taken to its end, makes no sense. What they would seek to have this court believe is that if a party, as a seller, is not using reasonable diligent efforts, and either that comes to the knowledge or belief of the buyer at any point during the cure period, however it's invoked, and there's no question here that there was a cure period, they admit it. They admit that they told my client through his attorney, hey, there's this issue, we're not sure about what it actually means, but we're working on it, we're going to get it resolved. That story never changed. The first time that story changed is when I, on behalf of Dr. Vito, sent a demand a year later for them to close under the contract after Dr. Vito had been strung along for an
To
entire year.
preserve a claim of specific performance, do you have to give earlier notice that there's a failure to diligently cure?
Your Honor, I don't believe you do, because the Florida rules of civil procedure specifically provide that the statute of limitation for commencing a specific performance complaint is a year. It doesn't have a carve-out or a caveat if it has to do with trying to enforce a real estate contract.
So any of that would be latches or failure to be.
Latches or some argument that was not, by the way, raised by the defendants at any point. So what they want to have you believe is that once they failed to use reasonable diligent efforts, and the trial court clearly found that they did, at that point, Dr. Vito was actually stripped of his right to seek to specifically perform under the contract. That's not what the contract provides. The contract provides a very limited carve-out which says if, as the seller, you're notified by the buyer of a defect, the buyer has the ability to tell you, you got to go fix it. You have a period of time in which to do it. And if you fail despite the use of reasonable diligent efforts, plural, at that point, then the buyer has a certain number of rights. He can either extend the contract further to give you more time. If you say, hey, give me more time, I'm working with so-and-so to clear the mortgage, I just need another week, fine. But if at any point, the buyer says, I don't think, seller, you're using reasonable diligent efforts, they're not required to sue that day, or the following day, or before any period in the contract. They have a year under the statute in which to seek to specifically perform under the contract.
And actually, they sent a notice in June, so it was well within a year.
And the reason that was sent,
diligently trying to cure this defect.
that's exactly right, Your Honor. And I do want to clarify one thing for the record. The counsel has said on behalf of the appellant that there were no acts taken between when they claim, and this is, I think, an important point. They claimed at trial, by the way, that the contract terminated on March 31st. Their argument for that was, well, because that's the 60 days for closing from when the contract was signed was March 31st. They had taken various positions throughout this litigation, various positions as to when the contract terminated. In fact, the parties at deposition, and this is part of the record, and it's part of the judgment, could not identify the year, let alone the month in which they alleged that the contract terminated at the time.
We know at least by April the 1st, it hadn't terminated because they have responded internally, but not to your client, that they think they should extend, and so they're operating under the supposition that the contract's still in force. But I would agree with the appellant that after that period of time, there's no real evidence that they believe this contract is still ongoing because they are refusing to respond to any of your inquiries about what's going on.
And Your Honor, it's not just a refusal to respond. They claim that silence can equal acquiescence on the part of estoppel, but it's not just silence. The defendants here, D&E, the appellant, was represented not only by Mr. DeJure, but also by Mr. Vendito that you referred to earlier as bankruptcy
But
counsel.
now, he was representing Imperial and Mel Cooper, which are different entities and parties.
No, Your Honor, Mr. Vendito was hired by the principals of D&E, not Imperial. Two of the principals of D&E are also principals of Imperial. But David Cooper and Eric Ramos, along with David Cooper's wife, Kara Cooper,
Yeah, but this is Mel
hired.
Cooper. My
The
understanding.
bankruptcy case was Mel Cooper. There was two bankruptcy cases.
No, it's
Imperial.
my understanding, and correct me if I'm wrong, and opposing counsel can answer the question too. It's my understanding that Vendito was hired and was representing Imperial and Mel Cooper.
No.
That's not correct.
That's not correct, no. So what happened is Imperial filed for bankruptcy by Mel Cooper, who is, David Cooper's father and the other member of that entity, along with David Cooper.
And they were all saying, you don't have the right to file
You
this.
can't put Imperial in bankruptcy, and there was some argument about that. At the same time, Mel Cooper personally filed for bankruptcy. So before, by the way, D&E notified my client through counsel of the title defect, they filed a motion to dismiss in the bankruptcy case. That motion to dismiss, that's where Mr. Vendito comes in. He was their bankruptcy lawyer. He was not hired by D&E, but the principals of D&E to seek to dismiss the bankruptcy case, not on behalf of Imperial. Typically, you would have them hire a lawyer on behalf of Imperial if they were claiming, as they did the motion to dismiss, hey, you, rogue member of the entity, you didn't have the authority to put us in bankruptcy. That's not what they did. The motion to dismiss clearly states that it's being filed on behalf of the individual defendants with respect to D&E.
But was Mel Cooper a principal of D&E as well?
No, he was not.
So that's where I think I'm confused then, because it appeared to me that David Cooper and Eric Ramos, and I guess David Cooper's wife, were the principals of D&E, as opposed to Mel Cooper, Eric Ramos, and David Cooper being principals of Imperial. And I see them as two separate entities, so when Imperial is filing for this bankruptcy, it's filing it on behalf of Mel Cooper, not on behalf of D&E.
That's correct. So what happened is there was 12 condo units at Fontainebleau that basically Mel Cooper and David Cooper and some of their business associates bought pre-construction. So this is going back 15 years. Within a couple of years, one of the business members split off, so instead of having 12 units, they had 8 units. And then eventually David Cooper and his father, Mel Cooper, get into a fight. And so they split up the 8 units they were holding, and D&E took 4. Mel Cooper then claimed in 2011, by the way, you couldn't take those units from Imperial. That's a fraudulent transfer. And he filed litigation in Miami-Dade Circuit Court, and he claimed that it was a fraudulent
But at the
transfer.
time he files the bankruptcy, Imperial and Mel Cooper have no interest in those 2 units.
Well, he claims that he does, and that's the entire thing that creates the title defect in this case, and is why we're here, is because when he filed the Imperial case, one of the things he said in the schedules that they own as real property were these 2 units. So that's what created the title defect, is he said, notwithstanding the fact, by the way, that he, on behalf of Imperial, had sued D&E and Mr. Cooper and Mr. Ramos, David Cooper and Eric Ramos, in Miami-Dade Circuit Court, exerting the exact same claims that the units were fraudulently transferred from Imperial to D&E in 2011. That case was dismissed with prejudice. With prejudice. Then when the units that were still subject to a pending foreclosure sale were reset for foreclosure, inexplicably, Imperial filed the exact same cause of action with a different attorney. The complaint was almost identical. And the defendants, D&E and Mr. Cooper and Mr. Ramos, didn't run to court and say, wait a minute, this same complaint, this same cause of action has already been dismissed with prejudice. You can't sue me again. And more notably, they didn't present that document to Mr. Vendito, their bankruptcy lawyer, nor to the bankruptcy court to say, we got a silver bullet. He can't now claim in bankruptcy that they have an interest in these units because this has already been adjudicated. This is res judicata. They never raised that argument. So clearly, going back to where I sort of started a few minutes ago to say it wasn't just silence from which a estoppel arose here. It was affirmative acts that were taken by D&E's lawyers. First, and this is in the record from trial, Mr. Littman, when asked about that April 1st email that he sent, you want to extend the closing? When asked, because there was no record that Mr. DeJure actually responded to the email in writing. Did he ever get back to you? Did he ever indicate to you that the sellers want to extend? He said yes. Okay? That's in Appellate's Appendix, page 203. And Mr. DeJure testified, and this is in Appellate's Appendix 1202 to 1203. He said, I suggested, this is him talking to Mr. DeJure about talking to Mr. Littman. I suggested to him that they could close whatever time they wanted. Obviously, that's not true. They've since admitted that that wasn't the case. But he goes on to say, my understanding was that there was an issue raised in the title, by the title company with respect to a cloud on title. So I told him we were communicating with the trustee to see if we could get the trustee to waive or release any claim against the property which would allow him to close. So you have D&E's lawyer telling Dr. Vito's lawyer, we're going to work on it. We're going to work on it. That story never changed. So regardless of whether or not you want to apply the law and the facts and the result being that they lulled Dr. Vito into simply not formally, by some deadline that they can't even still to this day establish when that was, to formally
and when that's
say,
being represented that they're working on it in this regard, that's when the lawyer, Mr. Littman, then calls the bankruptcy lawyer to find out if what's happening there.
Mr. Littman, who's been doing this for 35 years, gets the notion, this is his testimony, that something's not right here. Mr. DeJure's not responding to him. He's not getting any traction. This hearing, by the way, that we've heard about, that the representation is, hey, by the way, this bankruptcy thing came up. We're going to take care of it. It's set for hearing on March 28th.
And
That's
they find
before
out
the closing.
nothing's happening on it because the judge has already said, tell me what property you want to take out of this, and I'll do a stay order on that property. So he's calling to find out if that's happening. He then calls Vendito, find out what's going on. Vendito says, send me the contract. So he does.
Absolutely. And Vendito doesn't just say nothing in response to what's going on. He actually affirmatively, in those emails, tells both Dr. Vito's lawyer and the lawyer for another entity who was trying to buy another unit at Fontainebleau
That
from
contract's still
D&E.
enforceable.
No, he eventually questions internally whether or not the contract's still enforceable, but in June, he says, or July I believe it is, he says to Mr. Littman, I've spoken to the trustee, and they're definitely willing to consider the sale of the property to go forward. That's not silence. That's affirmative acts, and there are numerous affirmative acts that were taken on behalf of D&E to tell Dr. Vito through his counsel, don't
My
worry,
only
we're
concern
working.
with that is that the Vito, in my opinion, didn't represent D&E.
He absolutely did. Their position, I'm sorry to interject, but they absolutely made the argument all throughout this trial. The record is replete with allegations from them that Mr. Vendito was their lawyer, D&E's lawyer.
Okay.
They said that the reason why the retention didn't actually show D&E, because we made an issue out of that. We say, well, if you look at the bankruptcy docket, there's not a single filing in the case from D&E. Why didn't D&E do anything? And they said, well, D&E did do something. D&E filed a motion to dismiss. And we said, no, it didn't. Two of its principals filed a motion to dismiss. Maybe they were acting on behalf of their interest in Imperial. Maybe they were acting on behalf of other business interests that they have. But they surely didn't anywhere in that motion say anything about 2 units at Fontainebleau or trying to get them released from the bankruptcy. They didn't say anything about the fact that they'd already gotten an adjudication of the merits of the fraudulent transfer action previously in the 2012 dismissal with prejudice in Miami-Dade State Court. They certainly didn't say, oh, by the way, these cases are pending foreclosure in Miami. And they didn't say, by the way, with respect again to this notion, the reason they got tied up in the bankruptcy case to begin with is the allegation on behalf of Mel Cooper wearing his Imperial hat, that those 4 units, including the 2 units at issue here, were fraudulently transferred from Imperial to D&E when there was the breakup between David and his father. Subsequent to that, Kara Cooper, who was the managing member of Imperial, got together with David Cooper and Eric Ramos in 2013 and ratified the prior, on behalf of Imperial now. This is an action they took on behalf of
I
Imperial.
think we're getting kind of far afield.
Well, but they ratified the transfer. And the reason why that's material is there's another piece of paper that D&E could have taken to the bankruptcy court, presented to its bankruptcy lawyer and said, here's proof that Imperial doesn't have an interest in these units. That's all they would have had to have done. And the bankruptcy court, you don't even have to assume what the bankruptcy court would have done or would have done, because as the trial court found, the best indication of what the bankruptcy court would have done is what the judge said she would do. And that's without having the benefit of any of the documents that I'm talking about. Without the benefit of any of that factual background, she said, you file a stay relief motion, and I quote, I will grant it. That's exactly what the title company said was required here to allow the sale to go forward. And Mr. Littman sends that document, the title report, the second title report, which is the first time, by the way, that the title actually comes up. He sends that to Littman. I'll just finish that one thought. He sends it to Littman, and he not only sends it to him, but he actually cuts and pastes and says, here are the title requirements. One of them is stay relief. That was 2 weeks after Mr. Vendito went to court and heard the bankruptcy judge say, I'll give you stay relief. And he says nothing. He says nothing.
And in conclusion?
In conclusion, Your Honor, because the trial court's extensive findings of fact are support, which, by the way, have not been questioned here and cannot be called into doubt, are based on substantial evidence, and D&E makes no arguments to the contrary. Those findings should be upheld in their entirety. And because the trial court's conclusions of law are consistent with applicable law and support the result the trial court reached, this court should affirm respectfully the final judgment in its entirety.
Thank you. 2 minutes.
Thank you, Your Honor. This happens at the trial court level, and I understand why. There's lots of facts out there that if you want to cherry pick, go get on. But we've forgotten the very basic principle, and I think that the trial court forgot a very basic principle. It's that specific performance is simply rendered. And under Free versus Free, which is a 2006 50 CA case and cites the 2 first CA
I'm
cases.
sorry, which case?
Free versus Free is cited in the, I believe, in the reply brief, but the quote is the relief requested in a suit for specific performance may be granted if it is first established that the contract is valid and enforceable. And I think that the trial court forgot that, and I'm asking that this court uphold that, because you can't get the equitable relief unless you can prove a breach as a matter of law. And I do not think that they did that, and here is why. If you listen to opposing counsel's argument, when in response to, I believe, Judge Rothenberg, your question, which was, well, I'm sorry, it's Judge Salton, and I think you kind of hit the nail on the head. And the question was, well, if they're never exhibiting good faith or reasonable diligence, then what happens then? And to follow the appellee's logic, the answer to that question really is, well, the contract goes on in perpetuity until they get it right. And that's not what the contract says, and Your Honor, Judge Salter brought that point up. If there's a breach, there's a breach. And what the trial court found, because the trial court overlooked the fact that specific performance is simply a remedy, he looked at it holistically over everything. And I'm saying, under the law, pure contract law, you cannot do that. You cannot do that because these two parties entered into a contract that set forth a very specific scheme as to what happens in the event that at a certain point in time, be it March 31st or April 7th, that clean title can't be provided. Either you extend for 120 days, you take it as is, as the plaintiff in the Kubitschek case did, or you walk away and you get your money back. Buyer here didn't do anything, so the only way that they could and should prevail is if he was going to take title as is, which he testified he would not, and that's not an issue here, or my clients breached while the contract was in force. While the contract was in force, based upon the trial court's findings of fact, and I understand that the trial court may have hamstrung himself because he looked at it as being a contract essentially in perpetuity. But if you look at what could have been done, this is where the Gulfview case comes into play. Mr. Gay said, quote, all they could have done was present this paper to the court. Well, there's no record of evidence to show that not only would that have been sufficient, more importantly, would that have been sufficient to resolve the title issues prior to the date that this contract terminated by its own terms. Gulfview, which came out of this court, was the court ruled as it did, and in fact, I'm sorry, it was a 4th DCA case. The 4th DCA case said that the simple act of seeking an appeal, it was a close call, but that was sufficient, but then everything that it did afterwards brought us back into the, well, was this reasonable? Big distinction. In Gulfview...
Well, an appeal is a little different. You never know how that's going to turn out.
I understand that.
When a judge tells you what the turnout is going to be, that's a little different.
That's the point. And what the 4th DCA held there, and it's important to note that in Gulfview, there was no time of the essence clause. There was no deadline by which this has to be done, but what the 4th DCA was prevented with wasn't counsel saying, well, this would have worked. They had actual evidence that the buyer got 3 different options that could have timely resolved the issue that the seller just refused to do. There was no similar evidence before the court here, and the evidence upon which the trial court found a lack of reasonable diligence prior to, there has to be some cutoff, and it can't be June 13th. It cannot. The silence really is between April 1st and April 7th. Your Honor asked this, Judge Rothberg, you asked this, and you asked, well, what was it that would have lulled them into not exhibiting the right? She said, didn't say those words, but that's what your Honor was going for. And every single answer that opposing counsel gave to you, saying that there were affirmative acts, they either all occurred after April 7th, or with what we're working on it, there's no indication at all in the record of when that was. And surely, between April 6th and when the hearing was supposed to be on March 28th, there could have been communications back and forth. And of course we're working on it. And our position is we were working on it. So,
Well, over your time.
I apologize. Unless the court wants me to address Kubitschek.
Thank you very much.